So the Texas suppressor lawsuit, which seeks to stop the NFA and ATF's regulation of suppressors, is now having a hearing which is set for this week. So let's talk about this. But real quick before we jump into this video, if you think the NFA and the GCA need to be done away with, go ahead and hit that like button and subscribe. Also, I want to thank one of the main supporters of this channel, which is USCCA. Through your membership, you get training, education, and self-defense liability protection. So if you carry a firearm, I highly recommend you take a look into USCCA, and I will leave a link to them down in the details section. And I also want to mention, a lot of you guys ask me about the shirts I wear, like this Don't Tread on Me shirt, and then also where you can get my own channel merch. I will leave a link down below where you can find all the shirts that I wear, including this one, the Trash Panda shirt that a lot of you guys like, and then also my own channel merch. As I mentioned in the intro, in this video, we will be talking about the Texas Suppressor Freedom lawsuit, which aims to eliminate the NFA and the ATF's regulation of suppressors. The case we will be discussing in this video is called Paxton v. Dettelbach. This is an important and interesting case that now has a hearing set this week. So there are going to be oral arguments before a federal district court on this very issue this upcoming Thursday. This means that this week, the state of Texas and the ATF will argue before a federal district court judge in the state of Texas on whether or not the ATF has the authority to regulate suppressors that are made in and also remain exclusively within the state of Texas. Now, for those not aware what this lawsuit involves, how this came up, this is a lawsuit involving Texas House Bill 957, which passed last year. HB 957 aimed to exempt from federal regulation all suppressors that are made in and also remain within the state of Texas. The claim behind this law is that since these items are made and sold within the state, they do not fall under interstate commerce, and therefore they fall outside the purview of federal regulation by the ATF. In the original complaint, the state of Texas argued that federal regulations of these items that are made and stay within the state of Texas is not permitted since the law does not impact interstate commerce. They also argue that the federal regulation of these items by the ATF drastically impacts Second Amendment rights, and also now under Bruin, there is further support that this is a Second Amendment violation. Now, multiple times in this case, the ATF tried to avoid this Second Amendment burden by arguing that the Second Amendment is not implicated in this case at all because suppressors are not bearable arms and therefore they are not protected from regulation. In doing that, they hoped that they would not have to justify the restrictions with any relevant history or tradition. Now, as you can see, when it's convenient for the ATF, they like to argue that suppressors are not bearable arms, that they're not protected by the Second Amendment, but then also when it comes time for them to actually regulate these items and how the statute defines these items, they do in fact claim that these are firearms, i.e. bearable arms, and therefore they have the authority to regulate them. So you can see how they are on both sides of this fence. In response to that, Texas says that plaintiffs have already addressed this issue. Whether a firearm suppressor is itself an arm is not the proper question post-Bruin. The Second Amendment regulates conduct, not arms. The right to keep and bear arms, they state, includes the right to keep and bear all arms. For instance, they say firearms with or without suppressors, laser sights, scopes, and other items as well, including holsters. Texas states that it is immaterial whether the arms at issue are accessories that improve the usage of a firearm or parts necessary for the use of a firearm because both instances involve conduct covered by the Second Amendment. Similarly, the conduct of driving a car includes the conduct of driving a car equipped with a muffler. Whether or not a muffler is itself a car, or whether or not a muffler is necessary to the operation of the car. And the right to free press covers ink and paper. Even though ink and paper is not itself press, and even though it is possible to communicate words without ink and paper. So in the state's recent briefs, they point out that suppressors clearly fall under the protection of the Second Amendment. The ATF can allege these are not arms, but the Second Amendment also protects lawful conduct. Then Texas goes on to point out that the ATF's position that they would even potentially be able to regulate these because they are potentially dangerous and unusual arms is simply not true. Texas states on the dangerousness aspect that ATF argues that even if a firearm suppressor are arms, the Second Amendment does not apply to them because they are dangerous and unusual. Plaintiffs have already explained why firearm suppressors are neither dangerous nor unusual. Even the former second-in-command of ATF during the Obama administration has written that firearm suppressors are not dangerous. So they are even pointing to the fact that there was the statement by the ATF itself that said that suppressors are not dangerous. Then the state of Texas points out that suppressors are in no way unusual. They also then point to the ATF's own numbers in saying that the ATF admits that there is 2.6 million registered firearm suppressors and they are legal in 42 states. They then say that the ATF nevertheless insists that they're not in common use because there are some restrictions within 18 states on the purchase and possession of suppressors. The state of Texas says that none of this has anything to do with whether firearm suppressors are unusual. Instead, they argue that by the very numbers admitted by the ATF itself, suppressors are clearly in common use across the US, and based on this, the state of Texas argues that the judge here in this case should grant their motion for summary judgment and rule that the ATF does not have authority to regulate suppressors that are made in and exclusively remain within the state of Texas. Currently, this case is set to be heard on cross motions for summary judgment, and in simplest terms, a summary judgment motion can resolve the dispute of a case like this one without a full trial taking place. Both Texas and the ATF have filed cross motions for summary judgment, which means both of these sides want the court to rule in their favor right here and now. Well, the judge in this case will now hear these very arguments this week, this upcoming Thursday on June 15th. Federal District Court Judge Mark Pittman issued the following order in this case, which states, before the court are parties cross motions for summary judgment. The court hereby sets the parties motion for a hearing at 2 p.m. on June 15th, 2023. Counsels for all parties are ordered to attend. Counsel should be prepared to discuss all issues raised in the parties' motions for summary judgment and all matters pending before this court. So there is going to be very critical and very important Second Amendment arguments that are happening this week. Now, some of you may ask, who's the judge in this case? Who's hearing this issue? The judge in this case is Judge Pittman, and he is a Trump-appointed judge. Recently, he received some notoriety. He was in the media a little bit because last November, he ruled that the Biden administration did not have the authority to forgive student loan debt through executive actions. Judge Pittman also importantly has some interesting background. He is a former vice president and founding member of the Fort Worth chapter of the Federalist Society, and also he is claimed to be an early American history buff. So again, that's very interesting because of what this case deals with and the type of analysis that's going to occur in this case. For those not aware, the Federalist Society for Law and Public Policy Studies identifies itself as a group of conservatives and libertarians interested in the current state of the legal order. It is founded on the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary and judges to say what the law is, not what it should be. And at its core, the Federalist Society advocates for textualist and textualism and originalism and that type of interpretation when it comes to the Constitution. And that's important because, again, think of justices like Scalia and Thomas. That's the type of ideology that they used in Heller and recently in Bruin. So this is an interesting situation where we have the Texas Suppressor Freedom lawsuit set for arguments this week. And they will take place before a judge who all indications are would likely be in our favor, would be in favor of the Pro 2A side and also the type of arguments that would be presented under Bruin. So that's what's going on in the Made in Texas Suppressor lawsuit. Arguments will happen this upcoming Thursday. And again, this is going to be very interesting to see how this plays out. If we get any more information on this issue, I will let you all know. But if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. As always, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.